Hare Krishna. Welcome to Tax Guru YouTube channel. This is your own R. Pingle, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. Welcome to the video series What Law Says. And today we are going to discuss two important case laws delivered in 2025 under GST law. So let's dive into it. Let me allow to share my screen. Yes, so GST regime has witnessed a significant body of litigation addressing procedural safeguards, statutory powers of tax authorities, and the limits of executive actions. High courts have played a critical role in balancing what revenue protection with taxpayer rights under the CGST Act 2017. So, two important judgments that we are going to discuss today are delivered in 2025, one by the Delhi High Court and other by the Madras High Court. Clarify crucial issues relating to provisional attachment of bank accounts under Section 83, validity of GST notifications extending limitation under Section 168A, and protection of statutory rights of taxpayers. So the following case analysis provides a comprehensive understanding of these rulings for professionals, practitioners, and stakeholders in the GST ecosystem. So let's start with it. Today's first case uh, citation. Okay. So the case is Om Prakash Gupta versus Principal Additional Director General DGGI. So case court is involved Delhi High Court. Date of order 14th May 2025 and petition number is WP 11,000 of 2024 and subject matter, as I said, provisional attachment of bank account under section 83 of the CGST Act. Let's see facts of the case. So the Director General of GST Intelligence initiated an investigation against the petitioner for alleged wrongful availment and passing of input tax credit. It was alleged that the petitioner had what availed ITC of approximately 87 lakh from suppliers who were allegedly non-existent entities. During the course of investigation, the department issued what letter attaching the petitioner's bank account and Section 83 of the CG under the Section 83 of the CGST Act. The petitioner filed a writ petition before the Delhi High Court challenging the attachment order. So, petitioner contended that no proper proceedings were initiated before the attachment. The attachment was issued without forming the statutory opinion required under Section 83, and subsequently a show cause notice under Section 74 of the CGST Act was issued alleging wrongful ITC availment. So let's see issue under considerations. The key legal questions before the High Court were whether the provisional attachment of bank account under Section 83 of CGST Act was valid or not, whether the authority had properly formed the opinion that attachment was necessary to protect the government revenue, and whether the conditions for invoking Section 83 were satisfied or not. So let's see the legal provisions involved relevant to the case. The following provisions were central to the dispute. Section 83 of the CGST Act, which allows the provisional attachment of the property, including bank accounts, to protect the interest of the government revenue after initiation of proceedings under specified chapters. Section 70 of CGST Act deals with empowers officers to summon the persons to give evidence or produce documents during the inquiry. And Section 74 of CGST Act deals with determination of tax not paid or short paid due to fraud, suppression, or willful misstatement. So, following provisions were central. Again, the Rule 159 of the CGST rules, that is, provides the procedure for provisional attachment and objections there too. Supreme Court precedent, that is Radhakrishnan Industries versus State of Himachal Pradesh 2021, laid down strict safeguards for exercising powers under Section 83. So let's see what are the contentions of the SEC. The petitioner contended that attachment was arbitrary and issued without the intention of valid proceedings. The commissioner had not formed an independent opinion regarding the necessity of attachment. The action violated the safeguards laid down by the Supreme Court in Radhakrishnan Industries case. The attachment severely affected what the business operations and financial stability of the petitioner. These are the contentions of the assessee. Let's see contentions of the revenue. The department argued that the petitioner had allegedly availed fake ITC through non-existing suppliers. Proceedings under GST law had already commenced through summons under Section 70. The provisional attachment was necessary to safeguard what government revenue, and the action was within the powers conferred under Section 83 of the GST Act. Is what the revenue contended. So let's see now High Court observations and what High Court had. The Delhi High Court made the following observations. Provisional attachment is what? A drastic power and must be exercised strictly in accordance with the statutory condition. Section 83 requires that proceedings must be initiated under specified chapters. Commissioner must form an opinion based on the tangible material. In the present case, proceedings had already commenced through summons issued under Section 70, alleging regarding wrongful ITC availment were recorded in the investigation. Therefore, the court held that no interference was warranted at that stage with the provisional attachment order. However, the court clarified that the taxpayer can file objections under Rule 159 sub Rule 5, seek reasons from the authority, and challenge the final adjudication order separately. So, what principles laid down by this case are the provisional attachment power is extraordinary and must be exercised cautiously. It can be invoked only after initiation of the proceedings. The commissioner must form an opinion based on the tangible material. The taxpayer has a right to file objections under Rule 159 sub Rule 5. Once final adjudication is completed, the provisional attachment ceases to operate. That are the principles laid down by the given case. Moving further, let's see second case for the discussion. TVL Viola Fashions Private Limited versus Assistant Commissioner. Let's see case citation. Okay, court involved is Madras High Court, Madurai bench. Date of judgment 17 December 2025. Case number WPMD number 36017 of 2025. And judge or Justice Krishnan Ramasamy. Subject involved validity of GST notifications extending what limitation under section 168A. So let's moving further. Let's understand facts of the case. Petitioner challenged two notifications, that is notification number 09 of 2023 and notification number 56 2023, dated one is 31st March 23 and other is 20th December 23 respectively. These notifications extended what the time limit for passing the orders under section 73 of the CGST Act. Petitioner argued here that the notifications effectively curtail what the limitation framework and were inconsistent with Supreme Court orders extending the limitation during COVID-19 and statutory provisions of the Act as well. Based on these notifications, the tax authority passed an assessment order dated 20th August 2024 against the petitioner. So petitioner filed what? A writ petition seeking quashing the notifications and quashing of the assessment order based on the particular notifications. So let's moving further understand the what are the issues involved here. High Court considered whether the GST notifications extending the limitations were valid or not, whether the notifications were ultra vires the section 168 of the CGST Act, and whether the notifications violated the Supreme Court's order extending limitation during COVID-19. Very important. Let's see legal provisions involved in the given case. Section 73, that is CGST Act of it, determination of tax not paid or short paid without fraud. Section 168 of the Act allows extension of time limits during force majeure situations. Article 142 of the Constitution, that is related to Supreme Court powers to complete the justice used during COVID-19 to extend the limitations period, and constitutional Article 14, 265, and 246A, that is equality before law, no tax without authority of law in GST, legislative competence. Let's see what are the contentions of the assessee in given case. Petitioner argued that the impugned notifications were ultra vires section 168A. They contradicted the Supreme Court's order excluding the COVID period from limitation. They arbitrarily curtailed the vested rights of the taxpayers, and one of the notification was issued without the recommendations of the GST Council. So let's see what contended by the revenue itself. The department argued that the government had power under Section 168A to extend time limits. Notifications were issued in the context of the extraordinary circumstances during the pandemic, and the extension was necessary for proper tax administration and adjudication, is what contended by the revenue. Let's see what High Court observed and held. The Madras High Court held that the notifications were legally first unsustainable and exceeded the powers conferred under Section 168A. The notifications incorrectly interpreted the Supreme Court's order on limitation. The court ruled that the notifications arbitrarily altered the limitation periods, were issued on erroneous assumptions regarding the Supreme Court direction. So accordingly, the court declared the notifications vitiated and illegal and set aside the assessment order dated 28th August 2024. So the court directed that the order be treated as a show cause notice and allowed the taxpayer to file the objections. So what principles laid down by the given case? The judgment laid down the important principles like executive notifications cannot override what statutory limitation provisions. Very important. Executive notifications cannot override the statutory limitation provisions. Powers under Section 168A must be exercised strictly within the statutory boundaries. Supreme Court orders under Article 142 must be respected by administrative authorities, and taxpayer rights cannot be arbitrarily curtailed by retrospective administrative actions. So these are the principles laid down by the given case. So overall key takeaways from both the judgments discussed today are GST authorities must exercise extraordinary powers cautiously. Provisional attachment powers require strict compliance with statutory safeguards. Limitation provisions under GST cannot be modified arbitrarily through notifications, and courts continue to uphold the taxpayer rights and rule of law within the GST framework. So that's it for today. Thank you. Thank you so much for patient hearing. If you have any questions, observations, suggestions, then do let me know via WhatsApp, or you can also email and also comment below the video. So thank you. Thank you so much. If you are not yet subscribed to Tax YouTube channel, then do subscribe for it for latest updates and video series like this. Hope you are getting valuable knowledge from all these updates and video series. Thank you. Thank you so much once again. Bye bye. Take care. Hare Krishna.